Welcome back. To look at the legal side of this whole matter, I'm joined by Dr. Sam Amadi, legal practitioner and director of the Abuja School of Social and Political Thought. Dr. Amadi, thank you for joining us.
Thank you for having me.
So real quick, we have this situation here. The former governor of Kaduna State is at the EFCC, and next thing we're seeing is tear gas everywhere. Does he really have a question to ask? And is it necessary to have tear gas being thrown out by the security operatives to disperse crowds around there?
Well, whether it's necessary, not really. I mean, it depends on. Tear gas is, of course, a car control, used for car control in very extreme cases, depending on the nature of the chaos or the righteous nature of any gathering. So most of Nigeria, it has become a first reaction to crowd. So not just the FCC, we see even protests. Sometimes protesters are tear gassed unnecessarily. So that's the point. Again, legally speaking, the point is that the EFCC, like any other government institution, even not even known security organizations, have a right to protect facility. Ordinarily, the right to protest is also guaranteed. So you would expect that protests will be peaceful, orderly, and then there will be areas where protesters cannot, cross. Maybe the EFCC would have demarcated, would have, ruled out some areas, especially their facility. Actually, they may not like people to enter inside the place and protest. So if they have a proper delineation of where to protest and peacefully, orderly face where protesters should not cross. Then also peaceful protests require protesters to keep to that compact. So, okay, fine, we can protest because again, law enforcement, they ought not to be overawed. They ought not to be intimidated. So over the world, there's a certain hysteria around law enforcement and also certain politics, whether in the US or Nigeria, elsewhere, around law enforcement, especially of high-profile, maybe politicians or high-profile citizens, or in cases that are controversial. So you would expect the kind of show of force on both sides, of those who want to protest against Nasir El-Rufai, those who came to support him. Okay. But what's expected of the EFCC is to ensure that they do not infringe the right of citizens, especially the media that sees cameras.
In this case, from the report our colleague put out there, they actually seized their equipment and disrupted a live transmission of the occurrences of both sides. Anyway, but the question I would like to ask you before we let you go is this matter of phone tapping. I mean, that conversation where the former governor allegedly claimed to have tapped into the conversations of the NSA. What level of legal implications does that have?
Well, two things. If you look at the charges already brought before the court against him, two of them relates to the cybercrime law, which has some kind of specific provisions. One of them talks generally in terms of using any technology to tap into conversations, wiretapping. Now, from the clips of the interview I have seen, I watched the interview. He didn't claim to have himself tapped it, but the narratives would suggest that whoever tapped, he was in communication with whoever tapped, or whoever tapped later briefed him. So in two ways, lawyers first, there's a question around the formality of this trial, in the sense that it said the DSS and the Security Act talk about the SSS. But of course, there has been executive order from the decrees then by the military administration to allow them use DSS as official name or a trading name, but the name they actually be SSS. So there's some kind of procedural challenge on that. But substantively, the argument will be: did he wiretap, or did he conspire with someone to do that directly, or somebody did it and came to him? I got information. That's number one. Number two would be a case. The third charge is on the NCC law, and that relates to conniving or accessory after the fact. Somebody did it, you covered the person up. So would the fact that he knew and not disclosed constitute a liability or some facts that suggest some kind of conspiracy. It's not an open and closed case. It's going to be a lot of factual narratives matched to law. But many are of the opinion that maybe it'd be a difficult thing for the state to convict him on those charges. He could actually say he lied on television, and then the question would not be that he might be compelled, depending on the procedures, to disclose who told him, even if he was not himself involved in the alleged act. So, interesting case ahead, but not frivolous at all. It has a lot of merit on the face of it, but also with quite a lot of evidence and link between whoever did what with him as either an interested, involved, passive, or active participant. If it's so passive, just heard about it and believed it, whether it's true or false, that may not amount to sufficient evidence of complicity.
Dr. Amadi, in 30 seconds, how easy is it to tap the phone of the NSA, considered one of the highest levels of security in the country?
That's part of why people say maybe this is El-Rufai blustered. I mean, it himself to trouble. I would argue that it would be very difficult to tap into the conversation or the phone, except somebody within that precinct had reported what the NSA allegedly said. And it may not be a case of tapping, but a case of bluffing and busting into some problem now.
All right, thank you so much, Dr. Sam Amadi, legal practitioner and director of Abuja School of Social and Political Thoughts. Thank you for sharing your thoughts with us today.